Similar sort of provisions go towards fixtures. Part 3. Here, Part 3. A tenant is not entitled to remove a fixture without the consent of the landlord if the fixture is installed by the landlord. Some people think that once it's been put in, it becomes their property. I've had that in the old days of somebody got the landlord to put in a fitting and then they wanted to take it with them because they liked it. So I suppose that's the legislation saying no tenant, you can't do that. The tenant's remedies. The tribunal may, on application by the tenant, make the following orders if the landlord fails to consent. An order that the tenant may install the fitting. You see, this is where it's making an owner go and defend himself at the tribunal. If he says no, and then the tenant raises them at the tribunal, then you've got to put the case of reasons why. What's the next section? The tribunal may order that the tenant may install a fixture or make a renovation, alteration, addition to residential premises, but only if it is satisfied, 1, that the landlord's failure to give consent was unreasonable, and the second part of that is if the consent to the renovation, alteration, addition that is of a minor nature. So the tribunal now has the power to assess what's minor and what's not, and what are they going to use to base their opinion on that. There are some hints given to the tribunal here. The tribunal may determine that the landlord's failure to consent is reasonable if any of the following circumstances, but is not limited to those circumstances, and they've got a list of them here, that the work involves structural changes. If the work involves that would be reasonably capable to be rectified at the end, so if the change is something that you can fix up easily, okay? If the work involves internal, external painting. Now that was the one that worried us quite a bit. So it's not unreasonable for a landlord to say no, painting. Now those who heard me talk last time, we talked about the people who painted rooms and painted around wardrobes and then took the wardrobes away. So basically there's an exclusion here that the tribunal may say to the tenant if he says that it's unreasonable, but hang on, this involves painting. We have a direction here, they're not governed to accept or use it exclusively, but you can actually go outside and say, okay, no painting internal or external. So I think that's a little bit of capitulation there, don't you reckon?
Yeah, it's a lot better than what it started out.
Yeah.
I've still got some concerns about, I mean, I know we had the win about cosmetic. When I say we had a win about cosmetic, we never found out what cosmetic changes were, so but we don't need to inquire about that any longer because there's no longer...
Not a facelift?
Yeah, apparently not. But now they've decided that the new catchphrase will be minor changes, and again, we haven't been told what minor looks like. So at the outset of this discussion, I said we're still waiting on a lot of guidance from the tribunal, so we need somebody to actually interpret what that means. And no doubt there'll be a variety of interpretations, so we are in a state of flux a little bit here. But nevertheless, there will be people saying, well, I want to make these changes to the property. Landlords are going to resist, and we're going to end up in the tribunal. Interestingly, when this legislation came out, one of the 4 criteria for it was that they were going to reduce disputes with the introduction of this legislation. Seriously.
I've actually asked the question, is there an increase in the budget for the tribunal? Because with those, as Tim mentioned, we have, I think at the moment, 82 registered full-time and part-time members of the tribunal. When you see what is now going to be allowed to be started in the tribunal, there's not going to be anywhere near enough staffing within that tribunal to deal with the increased numbers. Now, if they're already doing something close to 80,000 files a year, you can imagine these disputes that are going to arise out of this piece of legislation that is going to be, particularly the ones where you can apply early. This file's going to have to be opened and all that sort of thing. So I reckon they're going to be understaffed, and I don't think the government likes the idea of having to increase the budget to fund more wages for staff of the tribunal. Okay, we're finishing this one off. Any work that is prohibited under any law, the tribunal could knock back that consent by the tenant. And any work that is not consistent with the nature of the property. Well, that's fairly broad. All of those that I've just read to you have no definition. So it'll be now in the hands of the tribunal to decide all of those factors. Leaves them a pretty open sort of run, doesn't it? Yeah.
It's going to be very interesting, Tim, because when you think about the ageing population demographically wise, and you look at the way building codes are changing to really allow disabled access, there'll be and then you factor in the health and safety aspects, there's going to be a lot of landlords that are going to be forced to put in handicapped access type changes to the building, which will then become sort of enforceable to address the health and safety. So
look, there hasn't been a major change in that interpretation. It's already been established that in Supreme Court that a landlord doesn't have to alter premises. You say, here they are, that's what you've got to make a decision where you can live here or not. So at the point of leasing, that changes those premises to put in handicap ramps and rails and bathrooms and that sort of thing, they're not bound to do it. And I believe that Supreme Court case will roll into this because there's no sufficient opting out in this legislation. So your fear there is partially eliminated, but people will go ahead and do these things without the landlord's consent. So then you're facing at the other end of the tendency looking for compensation for restoration back. Now, if they've drilled holes through tiles to put in rails, what's that going to do in relation to compensation to restore it back to the way it was when the tenant moved in?
Yeah, then they argue that this is a health and safety aspect.
Well, they also say that it's an improvement to the asset, but there are lots of people who'll come to a rental property and say, well, you know, we're not old people, we don't need rails and we don't want them there, so they won't take the property. So, but that's already been dealt with by the Supreme Court, and as I say, there's nothing in this legislation that I can see that would eliminate that Supreme Court decision. Huh?
But you mentioned it just there is no definition, and the law cover under reasonable, whatever is reasonable, and that's disputed in itself, because it doesn't matter what you do, there is what is reasonable, according to who.
Well, that's the problem, and there's one of our very early members of the chair of the tribunal tried to write a definition of reasonable, and he gave up after 8 pages, and he said there's nothing. So they resolved back to what are the circumstances of the individual case as to what making a definition of reasonable for that particular. So it's the evidence that's presented that actually dictates whether it's reasonable or not. So it's a one that there's no definition. You haven't got one hidden away, have you, Tim? Reasonable?
Reasonable. There is a definition of a reasonable man, not a reasonable woman. Would that help? There is the legal definition was given not last century. I think the latter part of the century before. And it was in England, and there is a particular gentleman who stepped off an omnibus in a particular street was considered to be the reasonable man. And that doesn't help anyone. So 8 pages of definition. I'm not surprised. And you just give up.
Does anybody remember Ray Collins, the first major chair of the tribunal? Well, he was the one who tried to do it, and he gave up. He said, "I can't do it."
No, you'll find the word reasonable throughout all legal documents, and precise definition of it. Nobody actually has. So it's how lawyers send their kids to expensive schools, essentially.